I'm telling you what to do, but you're not listening, Mr. Resto. Mr. Resto.
I mean, today, like, I want to resolve this today.
I get that you want to resolve it today, and I'm telling you what to do, but you're not listening to me.
If I enter like an oral motion of dismissal based on constitutional grounds, are you standing on your constitutional oath?
Okay, I'm not sure what that is. So I have taken an oath to uphold the Constitution and to make sure that I treat people as the law would direct me to do so. So,
well, I have no absolute reason to lie, and I really believe that.
No, it's not that, sir. This is what I would if you had an attorney who was representing you, okay?
I work in the court system. I don't work for the Secretary of State, so I can't tell them what to do. If you believe that you paid the money and you should have a license, you need to contact the Secretary of State.
Well, knowing that I think I had a license at the time, doesn't that change things?
It would change things only if it were true, and I don't know that it's true. Just because you believe it doesn't make it true.
Mr. Resto. So, Mr. Resto, you have two cases. You have case number. You hear me?
Yes, okay. I hear you.
So you're before the court on 2019 CR 04954 for driving on a suspended or revoked license, no license, failure to display license, or failure to have license on person. I'm not sure, it cuts off, and no tag or expired or invalid tag. So that's on the first case. On the case from 2020 03114, you have a suspended or revoked license. You're represented by Liston and Holt on one of the cases, but not on the other. Did you want Liston and Holt to represent you, or did you want to represent yourself?
I'll represent myself.
On both cases?
Yes, ma'am. I have a quick question as far as law concern when it comes to driver's license.
Okay.
Okay, you're only allowed to have one driver's license, and I have an Alabama driver's license. So when I get pulled over, I actually show them my Alabama driver's license, and it's current. It's the most current, and so they make a determination if they should go off the Georgia driver's license or the Alabama driver's license. And when I present the Alabama driver's license, they let me go because my Alabama license is valid, and you're only allowed to have one. And I had Alabama license first. So
I believe this sounds like a not guilty.
Okay, so Mr. Resto, what Mr. Taylor is saying is this is something that you could prove at trial. If you present that information at trial, then that means you want to go to trial instead of taking a plea. I don't know what the recommendation is, and I don't know.
Well, the recommendation was, I think I've been dealing with this case for an awful long time now, so yeah. I don't really want to go to trial. I just want to get it behind me. But I think that I remember the recommendation quite clear. They offered me 40 hours of community service. Is that still on the table?
Okay, no, Mr. Resto, it's more than that. So let me explain why I know it's more than that. So the basic fines and fees for driving on a suspended license is the first time in 5 years. If you get one, then you can enter a NOLO plea if you have a NOLO plea eligible to you. And then the fine is $500. But if you get a second one, the fine goes to $1,000. A third one, the fine goes to $1,500 and 10 days mandatory jail time. You have a second one, which means that you might be able to enter a NOLO to the first one, but then the second one is outstanding. So when you took a plea to the second one, that would definitely suspend your license. So that's what's on the table.
Okay.
And the fines are hefty. So you would get a plea on the first one, and that's a $500 fine, which is $737.50. But the next one is going to be $1,000 in addition to that, and that's $1,420. So we're looking at almost $2,200.
Your Honor, is Mr. Resto represented on the particular case that we're referring to?
Well,
I want to address him directly if he's represented, because this is a serious matter.
I get you. So that's why I'm saying, Mr. Resto, you have representation. I can allow you to be represented on both cases, and they can help you work this out. But understand
Well,
that.
I was already represented by Liston and Holt, and we kind of been going back and forth with the district attorney's office for a while, and they've been giving me recommendations, and I still didn't take it, but they've been giving me recommendations. I don't know what's changed, but it definitely
Okay.
wasn't $2,000.
Talk to your attorney and let them tell you what the recommendation they have on the table, okay? Because the recommendation, if you're represented, even if you're only represented on one case, the rec is probably going to come to your attorney.
Okay, now if I enter like an oral motion of dismissal based on constitutional grounds, are you standing on your constitutional oath?
Okay, I'm not sure what that is. So I have taken an oath to uphold the Constitution and to make sure that I treat people as the law would direct me to do so. So,
okay. Well, I asked this question previously when I was in your courtroom one day in regards to the right to travel under the 14th Amendment, stating that citizens do not need a permit to travel with a horse-drawn carriage, wagon, or automobile without interference by police. And I was on a public highway actually when I got pulled over.
okay, so that's not actually in the Constitution.
And
So
I don't
the right
believe
to travel,
automobiles
the
were
right to travel.
around when the 14th Amendment was ratified.
I'm sorry, go ahead, Mr. Taylor.
I just wanted to point out to the court that automobiles hadn't been invented when the 14th Amendment was ratified. That
Yeah,
may
it says automobile, horse-drawn wagon, or carriage.
Okay,
So an automobile is not necessarily a car if it's a household good. It's just a form of transportation. It doesn't matter if it's an automobile, horse-drawn wagon, or carriage, because it's still a form of transportation, and citizens have the right to travel without interference by police. So I don't even know how the police are even allowed to interfere with travel when I'm not using my vehicle for commerce.
Your Honor,
And it's
Hold on,
a
Mr.
totally
Taylor.
private household good.
Okay, so Mr. Resto, if somebody drove 100 miles an hour into the back of your vehicle and killed your a family member, would you want the police to interfere?
That's murder. I mean, that's if someone got killed.
But they're traveling. You can't interfere with somebody traveling.
No, I mean you can't. It's stating that a police just can't interfere with your traveling, like pulling you over for a traffic violation or a tag.
But you want them to interfere if somebody.
Now, if you murder somebody because of
say you don't murder them. Say you just hurt them. Say you just damaged the vehicle. You don't want the police to interfere.
No, that's when it almost becomes like an accident or a crime or whatnot. So the police can. That's not really an interference. An interference with your traveling, not an interference when two citizens engage in an accident. It's interfering with you just traveling. Now, police officers, as far as public servants, they have a duty to serve to the people. So if a car accident occurs, then of course public servants, as far as ambulance, as far as firemen, they will come to the scene just as a service. But for you to just interfere in my traveling is actually a violation of the Constitution.
Well, sir, the Constitution and the cases that have come out of the constitutional jurisprudence allow cities and states and municipal organizations to regulate travel for the benefit of the citizens. So they can put reasonable regulations on travel, meaning you can have a license. They can grant you the privilege of having a license to drive. They can regulate how your license is seen. If you don't have a license, or if your license is suspended, they can intervene to take your license away or your privilege to drive away. It is a crime. You can be convicted of not driving under a proper license. So the government is allowed to intervene in a lot of ways with people traveling. So I'm not sure where this information comes from, but there's a lot of stuff on the internet about traveling and the 14th Amendment and horse and buggies and even maritime law. But
I mean,
an
automobile was actually created before a driver's license was ever created. So people
Okay.
was actually operating their case pamphlets where people was actually operating vehicles before a driver's license ever became. That's actually, you guys are actually a conflict of interest, actually, as far as you being in cahoots with the DMV. That's a totally separate entity.
Okay,
And for
so
some reason,
Mr. Resto, do you want to resolve the case? Because it's
I
not going
want
to
to
be
resolve the
40
case, but
hours of,
I disagree with the fine amount because it changed. I would
It-
pay I would make an offer like I can do $1,000, maybe 12-month probation, but
Mr. Resto,
$2,000 that's excessive.
Mr. Resto, we're not negotiating. Those are statutory fines, meaning they're written into the law. I can't even change them.
Can I make a counter offer to the state and say it's $1,000? That can I be?
No,
Because I did do
sir.
time in jail. If the state would see that
Well,
and count,
That's why I'm saying that you may want to speak with an attorney because certain things that they can negotiate, I can't change the statute. I can't change what's written in it, but they can negotiate. And if the solicitor wants to give you credit for time in jail in lieu of the fine, those are things that they can do that I can't do.
yeah. So I would ask to the district attorney, knowing that I did serve some days in jail, can you guys
Okay.
lower the fine and I just go ahead and end this
So,
case right now? I can do 1,000. I got $1,000 right now.
Mr.
And
Mr.
Huh?
Resto, so that's a conversation that you need to have with them directly without me being present, number one. Number two, the reason I keep saying you might want to go through your attorney is because they can explain to you what is already on the table and how that may or may not change, okay?
what's on the table now, man?
I don't know. That's what I'm saying. I would rather you have that conversation in a breakout room with the attorney who's assigned to your case and with the state as opposed to here in the main room. One, because I have other cases that need to be addressed, and two, because that's not information I need to hear.
Okay, is it anything I can do to get this case resolved now? Because it's been lingering on
I'm
my
telling
head
you what to
for
do, but you're
years.
not listening, Mr. Reston. Mr.
I mean,
Resto,
today, like I want to resolve this today.
I get that you want to resolve it today, and I'm telling you what to do, but you're not listening to me. I said you can go into a breakout room with your attorney, and the attorney and you can discuss what's already on the table. And then if your attorney wishes to speak with the state to clarify anything, they can do that too. But you're not going to get it resolved by going back and forth.
This is the turning point. The court is offering a practical path toward resolution, but the focus has shifted from solving the case to defending a belief system. That's a common sovereign citizen pattern. The argument can feel personally important, yet every minute spent defending the theory is a minute not spent reducing legal exposure. In court, strategy usually beats certainty.
With me because there's
Okay.
stuff I cannot do.
Okay, just tell the state that I'll take their recommendation. I'll just pay the $2,000 if they can give me 12 months to pay it off. And
Okay,
if I
but,
can, and if I pay
sir,
it off early, if my probation can be terminated, that would be great.
Sorry, I was discussing with Mr.
Resto?
Resto, and I understand something changed about his bond.
Okay. He has bonds with two bondsmen. I don't know of anything. Did somebody come off a bond?
Your Honor, maybe I can address that question.
Okay.
Mr. Resto, our office filed a motion to revoke bond, and that motion was granted a rule nisi, and it was calendared. That motion didn't happen because of the pandemic. It was, I believe, scheduled to happen in 2021, maybe February, but somewhere about that time. I informed Mr. Kamani to inform his client that depending on the outcome of today's arraignment, the state intends to move forward on that bond revocation. Your Honor, may I make a request on that matter?
Sure, Mr. Taylor.
I'd request that the defendant show in person for him. Zoom court is or remote appearance is not sufficient.
So it's my understanding that you and Mr. Castaneda have parted ways with respect to your case.
Yeah. Did he file a motion to withdraw?
Yeah. Did you want to go forward without an attorney representing yourself?
Yeah, it seems like the attorneys that the state appoints me, they have a very hard time of like listening to their clients, like what they have to say. Like I had a conversation with him for like maybe 5 minutes, and he was very like wanted to do what he wanted to do. He didn't want to hear what I had, or he was just telling me like I was raising concerns about the state came off of my bond, and I was trying to figure out why they came off of my bond when I show up for court. I gave him no reason to come off my bond, and he said,
so when you say come off your bond, the bonding company has to do that, not the state. So I'm not sure. Like,
well, they filed a motion to come off my bond. That's what he stated.
Okay, is that Free at Last or Atlanta Clayton bonding?
No, not Free at Last. I have that you. He stated that the state filed a motion with your court, stating that they wanted to come off my bond to where basically I will have a warrant on me.
Okay, Miss Janvier, do you have any outstanding bench warrants for Mr. Resto? I don't recall signing any, but I may have.
Did the state file any motions in regards to
that? No.
Okay, I did. So just Your Honor, I didn't know that he was back. I'd already given the file to my assistant. She said she had just sent off the bench warrant to you as well, I think. So
I didn't think.
Okay.
All right. So yeah, Mr. Resto, you're here. So I haven't signed anything yet.
Okay. Does the state have any intentions on trying to come off my bond?
No. So, sir, they don't come off your bond unless you fail to appear. My understanding is you had a medical excuse for being late today. So you contacted
I'm actually still at the hospital. I just had a minor surgery.
Okay. So Ms. Val has allowed you to come on to the call today because she knew that you had a medical issue. So we can deal with your case today, or we can give you a continuance until December 6th, but nobody's coming off the bond and the bench warrant will not be signed.
Okay. I want to handle this today. It's kind of been lingering over my head for some years now. I'm really tired of it. And but I hear that the state is trying to like give me like 10 days in jail, and that would like absolutely ruin my business, my life. So I have a 2-year-old son, and I'm a single father. Yeah, but see, Judge, in my situation is okay, I got the documentation from the Alabama motor vehicle department. See, okay. I'm actually an Alabama citizen.
Hold on, I was traveling. Hold on. Let me put you in a breakout room with me and the state so we can hear what you're saying, but we're not putting it all out there in case you want to make a different decision, okay?
Okay. Well, I have no absolute reason to lie, and I really believe
No, it's not that, sir. This is what I would do if you had an attorney who was representing you, okay? So this is called a pre.
Yeah, but I just honestly believe that when you're just being truthful, there's really no need for attorneys when you're just being honest about your situation.
Next is Mr. Resto. Mr. Castaneda was fired by Mr. Resto, so he's no longer counsel of record. Mr. Resto is wanted, and there is no surety on that. Does the state have there's no surety order on that? Does the state have a request in the Resto case?
Mr. Resto, yes, state would definitely request a rule absolute in that matter.
Okay, on both cases, a rule absolute will be granted.
Thank you, Your Honor.
Turning to Ronald Hargrove.
Jonathan Baber on behalf of Mr. Hargrove.
All right. Is Mr. Hargrove here?
I do see a Ronald Hargrove name. There we go.
Okay. George. I think I just heard him. He's coming on. All right.
Thank
Okay,
you, Your
Mr.
Honor.
Hargrove, go ahead,
Yeah.
Mr. Baker.
Yeah, today is the date and time set for a couple of things. It's a status conference, Judge, but it's also a hearing date for my motion to withdraw. I'm really just going to rest on what I put in my written motion for this court. I really can't disclose too much more in regard to what the conflict is between me and my client without risking attorney-client privilege, and I don't want to waive that on behalf of Mr. Hargrove. But I do believe there's been a breakdown in the communication between me and my client. We just aren't seeing eye to eye on certain aspects, and I want to respect his wishes on how he wants to have his case represented. So therefore, I'm asking this court to consider withdrawing me from the case.
All right, Mr. Hargrove, well, first of all, Mr. Baber, you are appointed to represent him, is that correct?
I
Yeah,
am.
I do see that in your motion. Okay, give me just a second to.
And I want to stress to the court too, that Mr. Hargrove has been very respectful. It's just a situation where we just do not see eye to eye on certain things.
All right. So, Mr. Hargrove, you understand what, without getting into details, because I've read the affidavit of Mr. Baber, but do you understand what he is saying?
Yes, sir.
All right. Now, if I allow him to withdraw, which is what I'm leaning towards right now, I'm not sure whether there will be another attorney appointed for you or not. I don't know.
No, I was just confused about a bunch of things.
Right. But, you know, when there's a significant disagreement as to how to proceed, an attorney cannot go ahead and present something to the court that the attorney believes is not justified by law or fact, even if his client thinks it is. So he can't do that if he believes, I mean, that's against the rules that we have to practice under.
Okay. Well, let me ask you a question.
But you can ask it, I'll answer it if I can.
Are you the trustee for the Sesta KV account, Ronald Jean Hargrove II, or any account thereof?
Are you asking me that question? I have no idea what you're talking about.
You don't know
I
what I'm talking.
suspect the answer is no, but we're really not going to go down that road. Right now, the only question is whether or not Mr. Baber should be your attorney or not. He's filed a motion to withdraw saying that he can't, basically you have a disagreement on how to proceed. That's too significant for him to proceed.
Okay.
All right, so I'm going to allow him, Mr. Baber, was there an order that accompanied your motion?
No, Judge, I will prepare one and present it to the court by tomorrow.
All right, that's fine. I'll go ahead and sign that. Mr. Hargrove,
Yes, sir.
you wish to have another court-appointed attorney?
No,
Or do you want to represent yourself or hire your own attorney?
well, I guess I'm not going to get anywhere. No, my questions aren't being answered. So I don't know what to do.
Well, I need an answer. If you want to request another attorney, I can have you interviewed again by MIDC. They may or may not appoint an attorney for you or allow one. What do you want to do?
Well, I guess I'll go forward with an attorney, and
Okay,
because
so here's
I have a witness and some other things.
Okay.
I guess I need an attorney.
Well, I mean, it's up to you. I'm not necessarily going to appoint one for you. Ms. Parker, is Mr. Brown there?
Yes.
He just popped on. Mr. Brown, this is a bit of a new one on me. I don't know if you heard it all. Mr. Baber was appointed to represent Mr. Hargrove. He withdrew because they had some disagreement on what should be presented to the court. And I've allowed the withdrawal. Mr. Hargrove still wants a court-appointed attorney. Does that have to go to Mr. Slough, or is he simply re-interviewed by you?
I don't necessarily know if he even needs to be re-interviewed unless things had significantly changed, as he did have a court-appointed attorney. So unless things have significantly changed, I don't think a withdrawal would require a re-interview. I think he would just have to be appointed another attorney.
All right, so we'll notify Mr. Gilo's office of that. Mr. Hargrove, that attorney would be appointed for you. You'll be given the name and number of that attorney. You should give them a call. Pam, if you called, or that attorney would you also let them know they may want to call Mr. Baker.
I'll try to remember.
Yeah, okay, I get it completely. But Mr. Hargrove, I suspect that if this attorney has the same situation that Mr. Baber does, you may end up representing yourself or having to hire your own attorney.
Well,
Okay.
I wish you would just please answer my question.
Well, that's nothing that I can answer in a situation like this. The only question, you need an attorney, you've requested an attorney. If you're the next time you come to court, I won't be here because there'll be another judge. As my term ends at the end of this month, in about 10 days or so, 12 days. So any argument would be presented to them, but it has to be done according to the court rules that we're all bound by.
But you don't have to answer my question.
All right, Ronald Hargrove, file 24-43189 ST. I see you, Mr. Hargrove, on Zoom. You represented by counsel, Mr. Hargrove?
I represent Mr. Hargrove, Judge.
All right, thank you.
What we're going to ask the court to do is accept the plea to count one with the second offense dismissed.
Mr. Fortier, is that an accurate statement of the agreement?
I don't know yet, Your Honor. I can't find the case for some reason.
All right, I'll give you a second.
Mr. Gilo, did Miss Brooker email you that offer?
Yes, on the 9th.
Okay. Then yeah, Judge, that would be what we're gonna do then.
All right. Mr. Hargrove, you've heard the attorneys talk that there is an agreement being offered to you that if you plead guilty to the first offense of operating with your license suspended, the notice for second offense, which enhances the penalty, would be dismissed. Is that what you want to do? You're on mute now, Mr. Hargrove. You're going to have to take your, there you go. Is that what you want to do today? I'm sorry.
I just had a few questions.
Well, you're going to need to talk to your attorney about those questions. Do you need some time to do that?
He can't answer them for me.
All right. Well, then what are your questions? Let me see if I can answer them for you.
Okay. Well, I don't understand how you can be the trustee of my SESTA KV account, Ronald Gene Hargrove II, and not have my best interest.
I'm sorry. What? I don't understand what your question is.
How can you be the trustee of the SESTA KV account, Ronald Gene Hargrove II, and not have my best interest?
What is that account that you're referring to?
Oh, God. The SESTA KV account that everybody, most people have, and you're the trustee. Just like the Secretary of State is trustee of it. You are my trustee, aren't you?
Not that I'm aware of.
Uh-oh.
Why would I be your trustee? Mr. Gila, do you have some additional information that I'm not picking up on?
No, Judge.
It's just something that I believe in, and I've seen evidence of, and
What leads you, Mr. Hargrove, what leads you to believe that I'm your trustee?
Because of a former case I've seen.
A former case? What former case are you referring to?
In Roscommon, and a friend of mine asked the judge that, and he couldn't answer him. So
It's probably because it's not factually true. What information do you have that leads you to believe that I'm a trustee for you?
In that case, the judge quit 6 months into his new term because he was dishonored, and the sheriff. So,
Mr. Hargrove, the question was not about a Roscommon County case. It was about this particular case. You've alleged that I'm your trustee. I'm asking what information or proof that you have that is true.
So you're just denying it?
I don't know of any information that it makes it true.
Okay. If it was
what information do you have?
If it was a misdemeanor,
go ahead.
If it was a misdemeanor, would it be true?
No. Misdemeanors and trusts have nothing to do with each other.
Okay, well,
there has to be some court order for me to be a trustee for you. For anybody to be a trustee, there has to be a court order. Do you have such a court order?
No. I just believe that you are my trustee of the Susquehanna account, Ronald Gene Hargrove II, and that's.
Could you speak a little more clearly and tell me what that account is?
I'm not sure. I just believe that you are my trustee, and if you deny it, then you deny it. Okay, we'll move on from there. I guess, and another thing is I paid $1,000 for a reinstatement fee, but you guys keep saying I don't have a license. And where did my $1,000 go? I don't understand this.
Who did you pay $1,000 to, Mr. Hargrove?
The Secretary of State or the
Then you
State
need
of
to ask the Secretary of State.
Well, I believe I have my license, and they just there's a screw up somewhere.
Then you need to contact the Secretary of State, but I'm not connected to the Secretary of State. I'm the court system. I work in the court system. I don't work for the Secretary of State, so I can't tell them what to do. If you believe that you paid the money and you should have a license, you need to contact the Secretary of State.
Okay. Well, knowing that I think I had a license at the time, doesn't that change things?
It would change things only if it were true, and I don't know that it's true. Just because you believe it doesn't make it true.
Yeah.
All right, Mr. Hargrove, your attorney has told me, and the prosecutor has agreed, that there is an offer on the table for you to plead guilty to operating with license suspended in exchange for dismissal of the second offense notice, which makes this a much more serious charge.
Okay.
Do you want to accept that today, or do you want to have some additional time to speak with your attorney?
No, they don't have nothing to say to me. Their best interest is of the court. So I'll take that, and I would hope to get the same fine everybody else did today. Thank you very much.
Well, I can't guarantee that because you're in a different circumstance than everybody else.
Well, I'm pleading guilty to the same offense they just pled guilty to.
But your background is not the same as theirs.
You know what? I'll plead insanity.
These hearings show a pattern that appears in many sovereign citizen cases. The biggest legal risk often isn't the original charge. It's the decision to fight the case using arguments that the court has already rejected countless times. In the first case, the judge repeatedly explained the difference between a constitutional belief and the actual law being enforced in the courtroom. She also explained that some penalties were written directly into statute and couldn't simply be negotiated away. But instead of focusing on reducing consequences, the discussion kept returning to theories about travel rights, licensing authority, and constitutional interpretations that had no practical effect on the charges being discussed. In the second case, the problem became even clearer. The court was trying to address a straightforward decision, accept legal advice, evaluate the plea offer, and decide how to proceed. Instead, attention shifted toward trustee theories, hidden accounts, and questions that had no connection to the evidence needed to resolve the case. Psychologically, that can happen when someone becomes more invested in validating a worldview than evaluating risk. Once that shift occurs, every explanation from the court can start to sound like opposition instead of information. What makes these moments important is that neither judge responded with anger. Both repeatedly redirected the conversation back to procedure, evidence, and available options. That's where real legal outcomes are decided. Courtrooms rarely reward the most confident argument. They reward the argument supported by law, evidence, and procedure. And sometimes the most consequential decision in a case isn't what someone believes, it's whether they're willing to adjust their strategy when reality starts giving them a different answer.